Hello, everyone. Can I just check that you can hear me and you can see me? There is a chat function, so you just type in there. So I know. Great. Can you see me as well? Fantastic. Thank you. Because unfortunately, I can't see you. But anyway, let's get going. Hello, everyone. My name is Jo Reddy, and I will be taking you for the 8 sessions on commercial law. I will be delivering these lectures from London. If you have admin queries, please contact Space. During the lecture itself, use the chat function to ask questions. Now, it's difficult for me to speak and read your questions at the same time, but I will pause regularly to read questions and deal with them. Sometimes it will only be a short query, maybe asking me to repeat something or to spell something. It's best for me to answer short questions straight away. If it's a long question, then I will deal with it at the end of the lecture. Now, we will take breaks when we need them, but my plan is for 1 hour lecture, 10-minute break, 1 hour lecture, 10-minute break, and so on. Now, let's talk a bit about the commercial law syllabus. Our syllabus focuses on sale of goods law as well as the supply of goods and services. It also includes credit and security. On top of that, although our course is called commercial law, we're not dealing with pure commercial transactions. Our syllabus covers consumer transactions too. So we will be studying the CRA, the Consumer Rights Act 2015. Chances are that exam problem questions will focus on B2B contracts. But we need to cover B2C contracts and the CRA because we may set an essay exam question asking you to compare and contrast the regime for B2B contracts and B2C contracts. So consumer contracts is in the syllabus. Now, one topic I'm not going to cover at all is consumer credit. Consumer credit used to be done by coursework. It is now incorporated as an examinable topic. If we are going to set you an exam question on this, it will only be on the resit paper. It will not be examined on the main sitting. So I won't cover the topic. Now, consumer credit law is very interesting, but the problem with it is that unless you cover everything, it is not possible to answer one question on it. And it will take one whole lecture to do this. We can't afford one lecture if we only have 8 lectures to cover everything. So that's why I'm not going to cover consumer credit. I will deal with the topics in the order set out in the handout. What you need during these virtual sessions is the lecture handout itself. Now, to help us, I will have the names of the cases up on this screen, so it is easier for you to follow. But the detail is in your handout. Please do use the chat function to ask questions in class. It's the only way we have any form of interaction. In fact, I will be asking you questions. That's because after every topic, I intend for us to consider past exam papers. It puts the topic in perspective. Even if you know your lecture notes off by heart or you've memorized the textbooks, students fail if you cannot answer the question. We can't give you marks if your answer is irrelevant. So we will look at past exam papers after each topic, and I will be asking you questions. The only way you can answer my questions is to use the chat function. Anyway, I'm sure we'll get used to it. Well, we have no choice, of course. Okay, let's get going. Let's look at sale of goods contracts. It's very important to distinguish between B2B and B2C contracts because there are two different sets of rules. Our syllabus includes both. First thing to do is to see if the CRA applies. If the CRA does not apply, then the answer is the Sale of Goods Act applies. Just note that bits of the Sale of Goods Act still apply to consumers. For instance, the Memo Dat rules and the Transfer of Property rules, both of which we will study. The starting point always is this. When does the CRA apply? The answer is the CRA only applies to consumer contracts. So, what is a consumer contract? Well, a consumer contract is a contract whereby the trader supplies goods, digital content, or services to a consumer. Well, great, but who are these people? Who is a trader? Who is a consumer? Well, the definition is in section 2. A trader is someone who acts in the course of business. This includes companies, charities, government departments. The definition is very wide. If a charity shop sells t-shirts, the charity shop is a trader. Okay, so who is a consumer? Well, section 2 says a consumer must be an individual. In other words, it must be a natural person. That's you and me. Companies cannot be consumers. Businesses cannot be consumers. The individual is only a consumer if he does not contract mainly for business purpose. Let me make up an example. I sometimes work from home. I buy a kettle for use in my home. Yes, I am a consumer because the kettle is not mainly for business purpose. Whereas if my employer, if my boss buys a kettle for the staff room, the kettle is not a consumer transaction because it was bought mainly for business purpose. Example, I work from home and I buy a printer to print my invoices. Well, I'm probably not a consumer because the printer is mainly for business purpose. Query. If my business has not yet even started, but I buy an office desk, I buy an office chair, am I a consumer? We're not sure. We don't have cases on this yet. Now, the burden of proof is on the trader to prove that the buyer is not a consumer. If the buyer is not a consumer, the Sale of Goods Act applies. The Sale of Goods Act applies to C2C contracts too, consumer to consumer contracts too. But we will set the exam on either B2B, that's the Sale of Goods Act, or B2C, which is the CRA. Please do not be confused. The first thing to do is to check if the CRA applies. CRA only applies to consumer contracts. So go to section 2 of the CRA to check if the seller in your exam question is a trader or not. If the answer is yes, he's a trader, then great. Look at your buyer. buyer in your exam question satisfy the definition of a consumer under Section 2? If the answer is no, then the CRA does not apply. The Sale of Goods Act applies. Okay, so let's look at the Sale of Goods Act first. So we're going to look at B2B contracts first. There are 4 major areas we need to cover under the Sale of Goods Act. But first, we need to be sure that the Sale of Goods Act applies anyway, because the Sale of Goods Act only applies to a contract of sale of goods. So what is a contract of sale of goods? Well, Section 2, subsection 1 of the Sale of Goods Act says it's a contract whereby the seller transfers or agrees to transfer property in goods to the buyer for a money consideration called the price. Let's break this down. Section 2 sub 1 talks about a seller who transfers or agrees to transfer the property. Now, if the seller transfers property, this is a sale. This is when property has passed to the buyer. Hire purchase agreements are not sales contracts. Hire purchase is where you pay £200 a month for 2 years and you have an option to purchase. There is no sale contract until the hirer actually exercises the option to purchase at the end of 2 years, because it is only then that property is transferred. If the seller agrees to transfer property, this is an agreement to sell. This is when property passes at a later date. Example, I agree to sell you this pen next week. You don't own it yet. Now, if I don't go ahead with the deal next week, your action is for damages for breach of contract. But you don't have property rights. You don't own the pen. We are looking at Section 2 sub 1 definition of a contract of sale. Section 2 sub 1 talks about property in goods. What does property in goods mean? Well, property can mean the thing itself. I own my fur coat. My fur coat is my property. So property can mean the thing itself, my coat. But the wording is property in goods. Not just the physical coat, but something inside it. If I agree to sell you my fur coat, what I am selling you is the thing inside my fur coat. Essentially, we are talking about ownership of the fur coat. Ownership is something inside my coat. The definition of property is in Section 61 of the Sale of Goods Act. Section 61 says property is general property in goods, not merely special property. General property is essentially ownership. Think of ownership as a bundle of rights. I own my coat. That means I have the right to wear it. I have the right to lend it to you. I have the right to destroy it. I can do anything I want with it. I have more rights than anyone else. That's because I am the owner. I have general property in goods. Now, if I lend it to you, I give you the right to possession, but I still have all other rights. I am only transferring to you special property. If I sell you my coat, I transfer my entire bundle of rights to you. I transfer general property. So essentially, general property is ownership. It is the best possible interest. Special property is something less. It's a lesser interest. Section 2 says a contract is a contract for the sale of goods only when the seller transfers or agrees to transfer property in goods to the buyer. If the seller transfers anything less, it is not a contract of sale. So when I lend you my fur coat, this is not a contract of sale. You are just the bailee of my coat. You must take reasonable care of it. Sure, you have an interest in it, so if someone tries to take the coat from you, you have the right to get it back. But you don't have absolute legal interest. I'm the one with absolute legal interest. Sale of goods law is all about the transfer of this absolute legal interest in goods sold. Going back to the definition of a contract of sale, Section 2 sub 1 refers to price. So the Sale of Goods Act only applies where there is money consideration. If there is no money involved, the contract is not a contract for the sale of goods. Example, I say, if you buy my pen for $500, I will give you a free television set. You buy my pen. You give me $500 and I give you a TV set. Now, if the TV blows up, you cannot sue me for breach under the Sale of Goods Act because there was no money consideration. Okay, you gave me consideration for the pen, but the contract for the TV set is a collateral contract. Sorry, the question on the screen now is leasing a car is not covered by the Sale of Goods Act. The answer is it is not covered under the Sale of Goods Act because there is no sale. There's no transfer of property or an agreement to transfer property. You're merely hiring the car. The Sale of Goods Act does not apply. Going back to me selling you my pen for $500 and I promise to give you a TV set. If you give me $500 and I give you my pen, but it is the TV set that blows up, you cannot sue me for the breach of the TV set being faulty because that contract is a collateral contract. No money exchanged hands for the TV set. Now, you know the case from contract law, Andrews against Hopkinson. I will remind you of this case another time, but for now, what I am saying is that you gave me consideration for my pen, but my agreement to give you the TV set, that is a collateral contract. You did not give me money for that. To satisfy Section 2 sub 1, money must be involved. Checks, credit card, yeah, that's all money. But just because the parties forget to mention the price in the contract, it does not mean the contract is too uncertain. Again, from contract law, you know the topic of certainty of terms. If a contract does not mention the price to be paid, then the courts will infer, in other words, imply a promise to pay a reasonable price. The case is Foley against classic coaches. I'll remind you of the case now. The seller sold half of his land to the buyer on condition that the buyer bought all the petrol he needed to operate his coach business from the seller. After a while, the buyer didn't want to buy petrol from the seller anymore. So the buyer argued that a contract which did not stipulate the price to be paid for the petrol was just too vague to be enforceable. The court said no, it was an enforceable contract. The court implied a term that the buyer will pay a reasonable price. Now, as long as there's some money involved, the Sale of Goods Act will apply. So I offer to sell you my brand new Mercedes for 10 cents. Yep, the Sale of Goods Act will apply. 10 cents is okay. Remember, consideration must be sufficient, but it need not be adequate. Of course, you will remember the case of Chappell against Nestle. Nestle argued that he threw away the 3 chocolate wrappers anyway. The court said that doesn't matter. The chocolate wrappers still formed part of the consideration. Almost anything can amount to sufficient consideration. Suppose goods are exchanged for goods plus money. Is this a contract of sale? For example, a motor car dealer will take your old car in part exchange for a new car, or you trade in your old iPhone for the latest model. Is this a contract of sale? Well, the answer is it depends. We could look at the substance of the contract. Is money or goods exchanged the substantial consideration? Ultimately, it depends on the intention of the parties. If the parties intend for the transaction to be a sale, the Sale of Goods Act applies. So if you trade in your old car in part exchange for a new car, usually the parties intend for the new car to be a contract of sale. In other words, the Sale of Goods Act will apply. As far as the old car is concerned, the transaction is also a contract of sale, even though no money actually passes, because the notional price is set off against the new car. One case we need to know anyway later on is Aldridge against Johnson. The seller sold barley. The buyer gave the seller some cows and a bit of cash. The court said, yes, this was a contract of sale. We will come back to this case later on anyway. Section 2 sub 1 talks about goods. What is the meaning of goods? Well, there's a very long definition in section 61. Section 61 is the definition section in the Sale of Goods Act. Well, the definition of goods is a very long one. Read the definition in section 61 in your own time. Now, this chart kind of shows where goods comes in. This shows how it all fits in. You see, our syllabus concentrates on choses in possession. In other words, things that you can possess, things you can touch, like goods. Those are choses in possession. Choses in action are things that can be sold, but you cannot touch it. Things which cannot be physically delivered. You and I will be looking at negotiable instruments anyway, but our syllabus concentrates on choses in possession, goods. So what do we mean by goods? Well, there are 2 cases. Vackwell Engineering against BDH Chemicals. What happened in this case was a test tube contained a chemical inside it. The label around the test tube said harmful vapor. The scientist accidentally dropped the test tube into a sink of water. The chemical reacted so violently that the laboratory blew up and the scientist was killed. The court held that the label saying harmful vapor, that was unsatisfactory. So this meant that the goods were unsatisfactory. The other case is Wormel against RHM Agriculture. The Court of Appeal said goods means not only the goods themselves, but it includes the packaging, instructions, everything supplied with the goods. That's the importance of this case. Example, I buy a bottle of Coca-Cola. There's nothing wrong with the Coca-Cola inside, but there's a small crack in the plastic bottle and my Coca-Cola is dripping out of the bottle. Well, if that's the case, the goods are unsatisfactory because the court is saying everything supplied with the goods is goods as well. So the Coca-Cola inside is goods. The plastic bottle is part of the goods. Another example maybe is where, I don't know, I buy a hairdryer and the instructions on how to use it is in Arabic. Well, I suspect the hairdryer and the instructions on how to use it are unsatisfactory. Now, in Wormel against RHM Agriculture itself, instructions about when to use weed killer was not clear. The farmer interpreted the instructions reasonably. The weed killer was of no effect at all. The Court of Appeal said the weed killer was not fit for purpose. The important point about this case is that the Court of Appeal said goods means not only the goods themselves, but it includes the packaging, instructions, everything supplied. Now, computer hardware is of course goods, but what about software? The case is St. Albans against International Computers. A local authority, St. Albans, bought computer software for processing the community charge. The software was defective. The question for the court was computer software goods? And so was it defective under the Sale of Goods Act or the Supply of Goods and Services Act? The Court of Appeal said software alone is not goods. Software was merely licensed. Now, the CRA, the Consumer Rights Act, covers software, but the CRA only applies to B2C contracts. We are looking at B2B contracts, which remain governed by the Sale of Goods Act. But of course, even if the Sale of Goods Act does not apply to software, it does not mean that the business buyer has no remedy. The common law will imply a term that the software program must be reasonably fit for the intended purpose. When will a court imply terms in a contract? There are two tests: the business efficacy test and the officious bystander test. You covered this in contract law. I know that this is maybe 1 or 2 years ago, but commercial law is based on contract law. The principles are the same. We just take it further in commercial law, that's all. So dig out your contract law notes. I'm not saying relearn everything off by heart, but it would be useful to have your contract law notes to hand if you need to remind yourself something or some of these concepts. As I say, commercial law is based on contract law. So we do expect you to know your contract law principles. Back to the point I am making here. We are discussing the meaning of goods. The question is software goods? Well, the case of St. Albans against International Computers says no. Software is not goods. We're saying this causes a problem for the business buyer of software. Because if software is not goods, the Sale of Goods Act does not apply. But this does not mean the business buyer has no remedy if the software is defective, because the courts will imply terms into the contract anyway. How? Well, the courts will apply two tests: the business efficacy test and the officious bystander test. Let me remind you, because again, these comes back in commercial law all the time. The business efficacy test comes from the case of the Moorcock. This concerned the hire of a jetty to unload cargo. At low tide, the boat was damaged when it rested on a layer of hard rock. So the hirer sued for damage to his boat. The court said the hirer was entitled to damages because although the riverbed belonged to the local authority and it had nothing to do with the owner should have taken reasonable steps to find out if it was safe to moor the boat, because the parties must have intended this term. Otherwise, the contract is unworkable. The other important test is the officious bystander test, Share Law against Southern Foundries. The MD of a company was on a 10-year fixed-term contract, but this company was taken over by another company. The new holding company wanted to appoint their own man as MD, but they did not want to pay to get rid of the existing MD. He had a 10-year contract after all, so pretty expensive to get rid of someone without high termination costs. So what the holding company did was they changed the company's articles of association, entitling the holding company to change the MD without compensation. The MD sued for breach of the implied term that the company would not change the articles of association to remove him. The House of Lords said the MD was entitled to compensation. Yes, it was an implied term. The court said the officious bystander test is this. If a third party would say, of course, or of course not, then that term is implied into the contract. In this case, the holding company cannot go behind the MD's back by changing the articles of association to get rid of them. Of course not. We are discussing the meaning of goods. Is software goods? The answer seems to be no. This means that the business buyer cannot rely on the Sale of Goods Act provisions if software is defective. The business buyer needs to rely on courts implying terms into the contract under the business efficacy test and the officious bystander test. Now, it is common, of course, for computers and software to be supplied as a package, I mean, you get hardware and you get a bundle of preloaded software like Windows and other software applications. Strictly speaking, you are buying property in the computer, in other words, the hardware, and you are getting a license to use the bundled preloaded software. In Toby against Computer, the Supreme Court of New South Wales said that the sale of a computer system that's hardware and software is a sale of goods. Now, of course, Toby is an Australian case, so it is not binding on the English court, but it was accepted as good law by the judge in St Albans against International. But his comments were obiter. So English courts are, of course, definitely moving this way, though. In Fern Computer against Intergraph, Mr. Justice Mann said software supplied on a CD has a real chance of amounting to a supply of goods, especially, he said, if software was supplied with a physical dongle and documents. But software is increasingly supplied via downloads. It's a problem, isn't it? Because downloaded software is probably not goods under the Sale of Goods Act. See the important case of Computer Associates against Software Incubator. Now, this case concerned the commercial agent's regulations. An agent was appointed to promote software to consumers. Software was licensed on a perpetual basis and available electronically only, not via any physical medium. Question for the court was whether the commercial agent's regulations apply. Now, the regulations, you see, only apply if an agent is involved with goods. The High Court said, yes, software is goods for regulation purposes. The Court of Appeal was unanimous. The Court of Appeal said software is not goods. Goods is limited to a tangible property. The agent appealed to the Supreme Court. Now, instead of deciding the issue itself, the Supreme Court decided to refer two questions to the European Court of Justice. First question was whether computer software supplied electronically, in other words, not on any tangible medium, whether software supplied electronically is goods. Second question was whether software supplied under a perpetual license is a sale. The questions were referred by the Supreme Court to the ECJ in March 2019, the day before the original Brexit day. This meant the ECJ continued to have jurisdiction to hear the case. 3 years later, in 2021, the ECJ gave its decision. The answer is yes and yes. The first yes, computer software supplied electronically is goods, in the same way that software supplied on a tangible medium is goods. The second yes, a supply of software under a perpetual license is a sale of goods. Now, the ECJ decision is binding on the UK Supreme Court because it was referred before the end of the Brexit transition period. But I should just mention that under the Withdrawal Act, the UK's Supreme Court can deviate from ECJ case law when it is just to do so. But anyway, please remember that Computer Associates Against Software Incubator concerns the commercial agents regulations. It is possible that English law might revoke the commercial agents regulations and revert to common law principles on agents. In the meantime, what we can say is that Computer Associates is a significant decision on the classification of software. Now, of course, we've had these debates for ages. Is software goods? Well, you and I are downloading stuff all the time. If you think about it, physical goods are goods, no matter what method of delivery. I sell you a book. I send it by post. I send it by car. I send it by rail. It's still goods. Why is software different? Software on a disk, software downloaded, software on a subscription basis like a virus checker or a cloud-hosted basis like Dropbox. The law is trying to keep up, but failing miserably. At the moment, software supplied on a tangible medium, such as a disk, probably yes, goods. Software downloaded from the internet is not goods. Leads to odd situations. For example, if software is initially downloaded, but a backup copy provided is on disk, the backup, yes, is a supply of goods. But the initial download is not goods. It's crazy. It's not rational at all. The point is, the law is a bit out of date, but this needs to be sorted out by Parliament. But because the commercial agents regulations, they came from the EU, that's why the UK Supreme Court had to refer the question to the EU. And now the ECJ has come back with an answer. Yes, software is goods under the commercial agents regulations, but it's only for the purposes of the commercial agents regulations. It does not apply to the Sale of Goods Act. But of course, a future English court will bear in mind what the ECJ said in the Computer Associates case. Does it matter anyway whether software is goods? Well, yes, it does matter. It matters to the buyer, because if software is not goods, the Sale of Goods Act does not apply. I mean, hopefully the courts will imply sections 12, 13, 14 and 15 will imply the same terms under the Sale of Goods Act, but we can't be sure. Otherwise, you see, the business buyer has very little protection. Another reason why it matters to the buyer is that unless the terms fall within the Sale of Goods Act, the business buyer does not get the full protection of Section 6, Unfair Contract Terms Act. Section 6 UCTA says a seller cannot exempt for breach of Section 12 of the Sale of Goods Act, but the seller can exempt for breach of Sections 13, 14 and 15 if it is reasonable to do so. We're going to be reminding ourselves of UCTA anyway later on. So if software is not goods, the only protection for the business buyer is Section 3 upturn. All terms must be reasonable. This is a lower level of protection. Whether software is goods, well, it matters to the seller as well. Because if the software is goods, the seller can make his claim against the manufacturer of the goods. His claim goes back up the chain. Note, land is not goods. So if I sell you my house is land. So the Sale of Goods Act does not apply. Whereas if I sell you my, I don't know, air conditioning unit, which I will dismantle, yes, the air conditioning unit is goods. I sell you the wheat growing on my farm, yes, wheat is goods. Then the question here is, what about video games? Because hardly anybody buys CDs. I agree with you. We're downloading stuff all the time. What we're saying is, under the Sale of Goods Act, downloads are not recognized as goods. Remember, if you are a consumer, maybe it's the CRA that applies anyway. And the CRA does handle software. But we are looking at the moment B2B contracts, where a trader is selling to a business buyer. The business buyer cannot look to the Sale of Goods Act, where the business buyer has bought nothing more than pure software or something which has been downloaded. All right. Now, sometimes it is difficult to tell if you have a sale of goods contract. Let's look at the ROT, retention of title place, called res cogitans. This was a Supreme Court case back in 2016. This was the decision everyone was waiting for. It was a massive case involving the collapse of OW Bunker, the world's largest supplier of bunkers. Bunkers is a type of fuel used in ships. The company had debts of $750 million US. There was huge financial scandal. There were allegations of fraud by senior employees. Let me tell you about the facts of this case. The seller supplied bunkers, that's the type of fuel. Seller supplied bunkers to the ship owners. The contract terms included three things. First of all, an ROT clause, retention of title clause. Secondly, there was an express term that the buyer can use the bunkers, can use the fuel from the moment of delivery. Third, the ship owner had 60 days credit after delivery. The seller in this case bought the bunkers from suppliers who delivered directly to the ship owners. The contract between the supplier and the seller also had an ROT clause. The seller went bust. No one had paid anything at that time. The seller's liquidators claimed the price from the ship owner. The supplier claimed the price from the ship owner. The ship owner did not want to pay, not because they wanted something for nothing, but they did not want to pay twice. The seller was suing them. The physical supplier was suing them. The ship owner argued the seller can't sue for two reasons. First of all, because of Section 49. Section 49 says price is only payable when property has passed. So the ship owner said property has not passed to them because of the retention of title clause. The second thing the ship owner argued was that the seller did not have title to the goods anyway, because they had not yet paid their physical supplier. So the ship owner said the seller was in breach of Section 12. There were 3 questions for the court. We will only deal with question 1 now. We will come back to this case later on. Question 1. Was the contract a contract of sale within the meaning of the 1979 Sailor Goods Act? The Supreme Court was unanimous. The answer was no. It was not a contract of sale. Lord Mance delivered judgment. The contract itself called it a contract of sale, but Lord Mance said you need to look at the substance of the contract. This is an objective test. The Supreme Court said 4 conditions need to be satisfied before a contract is a contract of sale of goods under Section 2. First of all, goods must be involved. Second, the seller must undertake to transfer property in goods to the buyer. Third, there must be money consideration. Fourth condition is that there must be a link between the transfer of property and the money consideration. In other words, the buyer must be paying for property, not for some other benefit. What did the parties actually agree in res cogitats? The court said, yeah, 1 is satisfied. 3 is satisfied. There were goods involved and there was money involved. But, the court said, because of the terms of the contract, ROT clause, express term that the buyer can consume, thirdly, the credit period, the court said the parties knew property would never actually transfer to the buyer. The parties knew that the bunkers would be used immediately. In other words, the goods would be consumed before payment. The court said, if there are no goods at the time of payment, then there is no property in goods to pass. There is no link between the transfer of property and money. Essentially, the court is saying the buyer was paying for the right to use fuel, not for property. So the contract is not a contract of sale. Section 2 is not satisfied. So the 1979 Act does not apply. Wow. This decision took a lot of people by surprise. This decision has certainly been criticized. For example, Andrew Tettenborn says there are lots of contracts which are sale of goods contracts, even though there are no goods at the time of payment. For instance, CIF contracts, cost, insurance, freight contracts. Now, international trade, of course, is not in your syllabus, but essentially, risk in goods transfers to the buyer on shipment. But property does not pass to the buyer until payment is made against shipping documents. So if the ship sinks or the goods are completely destroyed, the buyer must still pay. When the buyer pays, the buyer gets property. there are no goods at the time the buyer pays, is res cogitans saying that the Sale of Goods Act does not apply to this CIF contract? I mean, look, even in a domestic normal situation, I agree to sell you my pen. I say it is your risk from right this very second, but I will only transfer property to you when you come back with cash tomorrow. Now, if the pen is damaged or stolen overnight, you must still pay me. Why? Because risk was on you. Is res cogitans saying the Sale of Goods Act does not apply to our contract? Now, res cogitans is suggesting that if there are no goods at the time of payment, then there is no property in goods to pass. If there is no link between the transfer of property and money, then it is not a sale of goods contract. Lord Muntz characterized the contract as sui generis agreement. Sui generis is Latin for of its own kind. In other words, something that is unique, something that is just different. In res cogitans, the contract had a feature quite different from a sale of goods contract. You see, the ship owner can use the bunker supplied without acquiring property before paying for it. But, you know, as we said, this is very controversial. Lots of contracts are sale of goods contracts, even though the goods are consumed before payment. Simple cases like a seller supplying goods to the buyer on credit with an ROT clause. Even though the contract contains an ROT clause, the buyer is not prevented from consuming the goods nor selling them to a sub-buyer before payment and property passing to the buyer. Now, you and I will be studying ROT clauses anyway, retention of title clauses. We will be studying that as part of our syllabus anyway. Res cogitans is a very upsetting case, actually. You see, we've always thought that these types of supply contracts were sale of goods contracts. So the Sale of Goods Act applies. But if Lord Muntz is right, the Sale of Goods Act won't apply to these sui generis contracts, and the buyer and seller won't get the protection of the Sale of Goods Act provisions. In other words, a contract which contains an ROT clause is not a sale of goods contract, but a sui generis contract. Well, res cogitans is disturbing established law. We will come back to res cogitans later. The point I'm making at the moment is that actually sometimes it is difficult to tell if you have a sale of goods contract. Assuming you do, then the Sale of Goods Act covers that transaction. There are 4 major areas in our syllabus. First, the passing of property and risk. Secondly, the Nemo-Dat exceptions. Thirdly, implied terms under the Sale of Goods Act, sections 12, 13, 14, and 15, plus the exemption clauses. And fourthly, ROT. Now, of course, we need to cover the CRA, and somewhere along the lines, will be miscellaneous provisions and the all-important remedies. All right. Well, I think that's a very good place to stop, take our first break, and when we come back, we will deal with passing of property and risk. So we'll take a 10-minute break. See you back here in 10 minutes. Okay. Okay. Hi. The very first big topic under the Sale of Goods Act is passing of property and risk. Now, sorry, I can see the question on the chat. Is the textbook Stokes on commercial law? The answer is yes, it is the 10th edition. That is the textbook. It is going to be available at end of November, apparently. Okay. Let's look at passing of property and risk. Whenever goods are damaged, the big question is, who bears the loss? The answer is the person with risk. So, who has risk? The answer is the person with property. Why? Because section 20, subsection 1 says risk passes with property. Okay, then when does property pass? The answer is it depends on the type of goods. So in a sale of goods contract, we need to know when the buyer becomes an owner, because whoever has property in goods, in other words, whoever is the owner, has risk in them. So if you own goods and something goes wrong, for instance, the goods are stolen, you bear the loss. Note that the law uses 3 words virtually the same thing: ownership, property, title. Now, I say virtually because it's not quite the same thing. We know the property definition in section 61. It means general property in goods, not merely special property. So essentially, general property is ownership. It's the best possible interest. It's the maximal bundle of rights. In this topic, we're looking at when this general property passes to the buyer. When does the buyer become the owner? We will talk about title later on. Back to property and risk. To find out when the buyer becomes an owner, we need to know what type of goods he's agreed to buy first, because the rules are completely different. There are only 2 types of goods in the whole world: specific goods or unascertained goods. There are no other types of goods. You look at the goods at the time the contract is made. Note straight away that the transfer of property rules are not affected by the Consumer Rights Act. So the Sale of Goods Act rules apply to both B2B contracts and B2C contracts. Risk is different though. Section 29 of the CRA applies B2C contracts. Section 29 CRA says goods are at the trader's risk until goods are physically delivered to the consumer. But the transfer of property rules are the same for B2B and B2C. Let's look at specific goods. What are specific goods? Well, the definition is in section 61. Specific goods are goods which are identified and agreed upon at the time of the contract. And it includes an undivided share specified as a fraction or percentage of goods which are identified or agreed upon at the time of the contract. It is very, very important to know whether goods are specific goods or not. Example 1. I'm a shop. I sell you this particular piano. Okay, the piano is specific goods. Example 2. I say, I will sell you 1 piano out of the 3 I currently have in my shop. The piano I agree to sell you is not specific goods. Not even if I put 1 piano aside and I put a label on it saying sold. No. Goods must be identified at the time the contract is made. At the time the contract is made, I had 3 pianos. I only agreed to sell you 1 of them. So you and I did not identify exactly which one was yours at the time of the contract of sale. I only put 1 piano aside and I put a label sold after the contract was made. So the piano is not specific goods. Example 3. I agree to sell you 3 pianos. I don't say from where. In fact, I happen to have 3 pianos in my showroom. The 3 pianos I agree to sell you, they are not specific goods. Not even if I intended to supply you the 3 pianos in my showroom. I could get 3 pianos from anywhere to satisfy my contract with you. Example 4. I say, I sell you the 3 pianos I currently have in my showroom. Now, yes, the 3 pianos are specific goods because they are identified and agreed upon at the time of the contract. The 3 pianos I sell you must be the ones in my showroom. I cannot get them from anywhere else. Okay. Section 61 goes on to say about an undivided share. Now, what does undivided share specified as a fraction or percentage mean? Because these are specific goods. Example, I agree to sell you 1/5 or 20% of this particular piano. Yes, it is a contract of sale for specific goods. Example is I agree to sell you half share in this particular piano. Yes, specific goods. Note that it must be undivided. So if the keyboard of the piano is, let's say, 20% of the piano, if I say your 20% is represented by the keyboard only, then it is not specific goods. All right, so we know what we mean by specific goods. Let's now look at unascertained goods. What are unascertained goods? Well, that's a good question, because unascertained goods are not defined in the Sale of Goods Act. So we can only assume that if goods are not specific goods, they must be unascertained goods. There are two types. The first is generic unascertained goods. Example, I agree to sell you 100 tons of wheat. That is generic unascertained goods. The second type is a specified quantity of unascertained goods out of an identified bulk. Example, I sell you 100 tons of wheat out of the 500 tons currently in my warehouse. This second type of unascertained goods, it's sometimes called quasi-specific goods, but I seriously do not recommend you use that phrase. You see, the rules about specific goods and unascertained goods are totally different. If you start calling unascertained goods quasi-specific, there is a danger that in the exam situation, you might end up getting confused and you use the wrong set of rules because you forgot that quasi-specific goods are actually unascertained goods. So although some textbooks call this second type of unascertained goods, they call it quasi-specific, I'm saying I think it is better if you don't. Just keep things straightforward. Goods are either specific goods or they are unascertained goods. Sure, there are two types of unascertained goods. And I know it sounds like a mouthful to say specified quantity of unascertained goods out of an identified bulk. I know it sounds like a mouthful, but you just have to note there are no shortcuts. Just learn it, because we are going to be saying it a billion times. What is the difference between these two types of unascertained goods anyway? Well, the only difference is that with the first type, in other words, the wholly generic unascertained goods, I sell you 100 tons of wheat. It does not matter where I get the wheat from, but I must supply you with 100 tons at the agreed time of delivery. With the second type, specified quantity of unascertained goods out of an identified bulk. In other words, I agree to sell you 100 tons of wheat out of the 500 currently in my warehouse. Well, I must supply you with wheat out of my stock in the warehouse. Okay, let me give you an example. You tell me whether this is a contract for specific goods or it's for unascertained goods. Let me give you the example. You tell me, is it a contract for specific goods or unascertained goods? I agree to sell you 500 tons of wheat out of the current cargo of 1,000 tons of wheat on board a ship called the Challenger. Is this a contract for specific goods or unascertained goods? Well done. The answer is unascertained goods. Well done. Because at the time of the contract, the goods are not identified and agreed upon at the time of the contract. You cannot tell exactly which blobs of wheat is yours. So section 61 is not satisfied. You are correct. So if goods are not specific goods, they must be unascertained goods. Those were the facts of re-weight. The contract was for 500 tons of wheat out of the cargo of 1,000 tons of wheat on board a ship called the Challenger. The court said this was a contract for unascertained goods. Re-weight is a leading case on this front. Unascertained goods are goods which are not specific. They are defined only by description. They are not identified nor agreed upon at the time of the contract. They are only identified after the contract is made. We need to be very, very clear what type of goods we've got, because as I say, the rules about passing of risk and property are very different. Look at the diagram on the screen. I agreed to sell you 500 tons of wheat out of the 1,000 tons of on the Challenger. Now we know this is unascertained goods. Those were the facts of re-weight. But what about I sell you all the wheat of the Challenger? Unascertained or specific? What about the situation when I say, I sell you all the wheat on the Challenger? I'm asking you, unascertained or specific? Excellent, well done. The answer is specific goods. Very good. Similar way, I sell you all the oil in my tanker. The oil is specific goods. You see, the wheat and the oil are goods which are identified and agreed upon at the time the contract is made. The goods are unique. They exist. I must deliver wheat or oil from that warehouse, that ship, not some of it, all of it. There is no reason why bulk goods cannot be specific goods. Just because parties can't say exactly how much wheat there is on that ship, it does not mean it is not a sale of specific goods. Of course, if the amount of wheat is very different from what the parties thought, then other contract principles come into play. For instance, common mistake. So, what are future goods? Because Section 5 says contract goods may be existing goods or future goods. Section 61, of course, is the definition section under the Sale of Goods Act. Section 61 says future goods means goods to be manufactured or acquired by the seller after making the contract of sale. So, are future goods specific goods or unascertained goods? Well, they can be either. Well, technically, it is not possible to sell future goods because property does not pass at the time of the contract. It is only an agreement to sell, but it still falls within Section 2 of the Sale of Goods Act anyway. Let's look at two cases on unascertained future goods. Kersell against timber operators. This case concerned the sale of timber, which at the time of the contract was growing in a forest in Latvia. Buyer was to chop the trees down, which were more than 6 inches in diameter, at a height of 4 foot from the ground, to be measured at the time of felling. At the time of chopping down the trees, the buyer had the right to choose them, chop them down if there's more than 6 inches in diameter, measured 4 foot from the ground. The buyer had 15 years to do this felling, chopping down. Shortly after the contract, the Latvian authorities confiscated the forest. The question was whether property in the trees had passed to the buyer. Well, this depended on whether the trees were sufficiently identified to be specific goods. The Court of Appeal said the trees were not sufficiently identified. They were unascertained goods because at the time of the contract, the trees were not identified and agreed. It was impossible to say which trees were within the contract. That's why property had not passed to the buyer. The second case on unascertained future goods is Sainsbury against Street. This case was about a contract for 275 tons of barley to be grown in a particular farm. The court said that the barley were unascertained goods. We will come back to this case later on. As I said, future goods can be specific goods. Example, I agree to sell you the piano which Elton John used at the late Queen's Jubilee concert and is currently owned by Elton John. This is a contract for specific goods. Now, I don't know if you know the case of Varley against Whip from contract law. Anyway, we need this case in commercial. Let me tell you about Varley against Whip. The seller described the reaping machine as nearly new and hardly used. At the time of sale, the seller did not actually own the goods, but the seller described the actual reaping machine which he agreed to sell to the buyer. The court held that this reaping machine was specific goods. We will come back to this case later on. Okay, so now we know what we mean by specific goods, unascertained goods, and future goods. But before we get into when the buyer becomes the owner, because whoever is the owner has to bear the loss, we need to look at risk and frustration, because it affects the contract itself. Let's look at specific goods first. We need to know two section numbers, section 6 and section 7. Section 6 says, where there is a contract for the sale of specific goods, and the goods without knowledge of the seller have perished at the time the contract is made, the contract is void. Note that section 6 only applies to specific goods. But of course, the common law position is the same. At common law, the general rule is, if the subject matter is destroyed or does not exist at the time of the contract, it is an operative mistake and the contract is void. The common law case is Couturier against Hastie. Corn was being shipped from the Mediterranean to England. The corn was overheating, so the master of the ship docked at the nearest port and sold the corn for the best price he could. The owner of the corn didn't know this. He sold the corn to the buyer. At the time of the contract, the seller nor the buyer knew that the corn no longer existed. The buyer refused to pay. The seller said, "It's the buyer's problem. The buyer must pay the seller in full, and whatever the master of the ship got for the overheated corn, that belonged to the buyer." The court said the contract was void because the subject matter did not exist at the time the contract was made. See, section 6 is saying the same thing. Note that section 6 talks about goods which have perished. Now, if goods are completely destroyed, for instance, by fire, or they've already been sold, which was the situation in Couturier against Hastie, sure, the goods have perished. But supposing they exist, but they've gone rotten, is that perished? We need to compare two cases. Asphar against Blundell. Let me just have a look at this question that's regarding the exam. Should we write the case names, or is referencing just one part of the case? Listen, you guys are not first year exam candidates, are you? You've already done contract law, you've done tort law. What did you do there? Did you write down just one side of the case? Of course not. You write down both sides of the cases. That's what I'm saying. Of course, there are exceptions to that rule. For instance, cases like, I don't know, fibrosa. Fibrosa is such a big case. They don't need to go fibrosa against Fairbairn Lawson. Fibrosa is good enough, all right? But follow in the same way as you did in contract law. Usually you have to give both sides of the cases, not the whole thing, just a little bit on both sides so we know you know the case. Of course, that merely depends on whether you want top marks or just medium marks. Top marks, you give both sides of the cases. So what we're looking at here is section 6. Section 6 says, where the goods have perished, sometimes the contract is void. Nobody's fault. What do we mean by goods have perished? what we're saying is, if the goods exist, but they've gone rotten, is that perished? We're saying, well, you need to compare two cases. The first case is Aspar against Blundell. Dates were accidentally soaked in sewage for 2 days. The court said dates had perished because they could no longer be bought and sold as dates, so they were commercially perished. Compare that case with Horn against Minister of Food. Potatoes were seriously rotten. The court said the potatoes had not perished because they were still potatoes, even though they were worthless. It was a valid contract. Buyer can claim for defective goods. Now, we're not really sure which of these two cases gives us a clear meaning of perish, but it is generally thought that Horn against Minister of Food would not be followed. Aspar against Blundell, that's the dates case, is preferred. So, if so, Section 6 does cover the perishing of goods in the commercial sense. But there are difficulties with this. I mean, one difficulty is the case of stolen goods. Let me just make up an example. I sell you my car. Unknown to either of us, my car was just stolen a few minutes ago, outside my house, just stolen. The police are looking for the car now, but it might be some time before the police give up all hope of finding my car. Until that happens, my car has not perished, not even in the commercial sense. But what about our contract? You and I can't wait forever until the police finish their investigation. Is our contract void or not? I mean, sure, yes, I know I can claim on my insurance, and my insurance will pay me because my car is a commercial loss. But it does not mean goods have commercially perished in the way we're looking at in Aspar against Blundell, where dates were soaked in sewage. You tell me what you think. Would Section 6 apply to this situation? You tell me. I agree to sell you the 700 bags of nuts now lying in my warehouse. I tell you those are the only nuts I have in my warehouse. Well, first of all, let me ask you one question first. Are the nuts specific goods or unascertained goods? I agree to sell you 700 bags of nuts in my warehouse. Those are the only nuts in my warehouse. Specific goods or unascertained goods? You tell me. Correct. Thank you. The answer is specific goods. Now, let's take this further. Unknown to you and me, 109 bags have already been stolen. Would Section 6 apply to avoid the contract? Remember, Section 6 says, where there is a contract for the sale of specific goods, goods without the knowledge of the seller have perished at the time the contract is made, the contract is void. What do you think? Would Section 6 apply to avoid the contract? Well, the answer is yes, it would avoid the contract. Section 6 would apply and the contract is void. The reason why the answer is yes, the contract is void is because those were the facts of Barrow Lane against Phillips. Now, I'm not saying this is not without difficulty, but those were the facts of Barrow Lane against Phillips. When the seller agreed to sell 700 bags of nuts to the buyer, 109 bags were already stolen. So the court said, yeah, contract was void under Section 6. Now, of course, coming back to my earlier query about my car, which I agreed to sell to you, but it's just literally been stolen. Okay, my car is a commercial loss, so I claim on my insurance. But my car is not really commercially perished. It's just that the police have not found it yet. You see, in Barrow Lane against Phillips, stolen goods were treated as commercially perished. But Barrow Lane involved nuts. Nuts were probably sold by the thieves and eaten by the end consumers. But you can't say that about my car. My stolen car might be smashed up, but it is still a car. No one is going to eat my car. So is my car to be treated like rotten potatoes in Horn against Minister of Food? Potatoes are potatoes, even if they are worthless. A car is still a car, even if it is worthless. Well, whether stolen goods have perished is open to debate. We need the courts to decide this. I suppose the way to deal with it in the meantime is to say that as a practical matter, if there is no prospect of recovering the goods should be treated as perished within the meaning of Section 6. Well, just one more thing about Section 6. It talks about goods have perished. This assumes that goods existed in the first place. If goods never existed, Section 6 does not apply. It is the common law that applies. In other words, Couturier against Hastie, and the contract is void anyway. Well, there is, of course, one exception to that, where one party has assumed the inherent risk that goods never existed. Now, I don't know if you studied the Australian case of McRae against CDC in contract. Whatever, it's a very important case, so I will deal with it here anyway. In McRae, the Commission invited tenders for the salvage of an oil tanker described as lying on a particular reef in a particular location in the South Pacific. McRae's tender was accepted. McRae incurred considerable expense organizing the salvage operation. Then they found out there was no tanker and no such brief. McRae sued for damages. The commission argued that the contract was void for mistake, so they would not be liable. The court held the contract was not void because the commission had impliedly warranted that the tanker existed. McRae was awarded damages which the commission had to pay. Actually, I remember now, I did have a look through your contract law manual, and McRae against CDC was in there. You looked at this case, I think, under remedies and damages. The salvage company was claiming reliance loss. Anyway, it's the same case. Now, McRae against CDC is a difficult case because the court said that the risk of the subject matter not being in existence was on the commission. Section 6 did not apply because the goods have not perished. They never existed in the first place. One more section we need to look at. This is section 7. Section 7 says, where there is an agreement to sell specific goods, and then, without anyone's fault, the goods perish before risk passes to the buyer, the agreement is avoided. Now, if the agreement is avoided, it means the seller does not have to deliver and the buyer does not have to pay. Both parties are excused. Note again, Section 7 only deals with specific goods. But, excuse me, essentially, Section 7 is the same as frustration. In other words, common law frustration. In other words, it is no one's fault that the contract becomes impossible to perform and it is fundamentally different. Maybe because the subject matter has been destroyed or the contract becomes illegal to perform. One case is Taylor against Caldwell. If you remember this case involved the hire of Surrey Gardens and Music Hall for a 4-day concert. The music hall burnt down before the concert, so the court said, yes, the contract is frustrated. It was impossible for the contract to continue. Okay, sure, Taylor against Caldwell is not a sale of goods contract, but it does show that Section 7 of the Sale of Goods Act is not much more than the common law doctrine of frustration. In other words, the contract is avoided. Note 2 things about Section 7. Section 7 says, where there is an agreement to sell specific goods, and then, without anyone's fault, the goods perish before risk passes to the buyer, the agreement is avoided. The first thing to note is that Section 7 only applies to an agreement to sell. So, if property has passed to the buyer, the contract cannot be avoided because Section 7 only applies to an agreement to sell specific goods. When does an agreement to sell become a sale? Well, an agreement to sell becomes a sale when property passes to the buyer. This is because the whole purpose of a sale of goods contract is that the buyer becomes the owner of goods. The leading case authority for this is Rowland against Deval. We will study this case later on anyway, for sure. Once property has passed to the buyer, see, the buyer has got what he wanted. So if goods perish after that, then it's his problem. Same with frustration. If the frustrating event occurs after the sale, the contract is not frustrated. For instance, I buy a car. The contract is complete. It then blows up. Well, it's my problem. The second thing to note is that Section 7 only applies where goods perish before risk passes to the buyer. So if risk has passed to the buyer, the contract cannot be avoided under Section 7. Example: I agree to sell you a specific car, that particular car. Now you need to organize cash and insurance. So I keep the car in my garage for you, but I tell you now that the car is your risk. So since risk has passed to you, the buyer, if the car is vandalized or destroyed overnight, the contract is not avoided under Section 7. It is only avoided if risk has not yet passed. That's what Section 7 says. So the car is your loss because it was at your risk. You must still pay me. Now, of course, we still have the problem where specific goods are part destroyed. Example: I agree to sell a buyer specific goods, and those goods are part destroyed before risk passes to the buyer. Does Section 7 operate to avoid the contract and discharge the seller's obligation? Well, we looked at the case of Barrow Lane against Phillips, where 109 bags out of 700 bags of nuts had been stolen. We said the contract was void under Section 6. Now, Barrow Lane suggests that if the contract is an unseverable contract, in other words, it was an all or nothing contract, then the contract is void under Section 6. But if the contract was a severable contract, and we will look at Maple Flock against Universal Furniture later in our syllabus, if the contract was severable, would it make any difference? Because usually the whole contract is avoided or the whole contract is frustrated. There's just nothing to affirm. But we have a dodgy decision in Sainsbury against Street. We mentioned this case before when we talked about future unascertained goods. Sainsbury against Street involved the sale of 275 tons of barley to be grown on a particular farm. We said this was not specific goods. There was crop failure and only 140 tons of barley was produced. The seller sold the barley to a third party. The buyer was now suing for non-delivery. The court said, although the contract was frustrated as to that part of the crop that failed, the seller was not entirely excused from performance. It was an implied term that the seller must offer the crop actually produced to the buyer. And the buyer had the option of taking delivery of a smaller quantity at a pro rata price. Now, of course, Sainsbury against Street is not a Section 7 case. It cannot be, because Section 7 only applies to specific goods. But the case suggests that where goods are part destroyed, frustration only affects that part which has been destroyed. So the seller is still obliged to offer the remaining goods to the buyer, even though the buyer does not have to accept part goods. But Section 7 says the agreement is avoided. It's like frustration. There is nothing to affirm. In the same way that Section 6 says the contract is void. All of it is void, not just some of it, all of it. So we have a problem where specific goods are part destroyed. Barrow Lane suggests that yes, the contract is void. But Sainsbury against Street, which of course is not a specific goods case, it suggests that only a bit of the contract is avoided or frustrated. Let's leave that point for the moment. We will come back to it another time anyway. Okay, so we've looked at Section 6 and Section 7. When specific goods have perished, sometimes the contract is void, sometimes the contract is avoided. Let's look at unascertained goods. What happens if unascertained goods perish? Well, Section 6 and Section 7 don't apply, because Sections 6 and 7 only apply to specific goods. So what about unascertained goods? The answer is it depends on the type of unascertained goods we're looking at. Now, remember, there are two types. The first is generic unascertained goods. Example, I sell you 100 tons of wheat. It is very difficult to frustrate this type of contract. If the supplier I had in mind cannot supply me anymore, I must get the goods from elsewhere. I cannot claim frustration. The contract is not void. The case authority is Blackburn Bobbin against Allen. The case involved a contract for birch timber. The seller usually gets his timber from his supplier in Finland, but his supplier didn't have any this time. So the seller told the buyer, sorry, contract frustrated. It was impossible to perform. The court said no, the contract was not frustrated. The seller and buyer didn't say that the birch timber must come from Finland. The buyer doesn't care where you get it from, as long as he gets his birch timber. So the contract is not frustrated. The seller is in breach for not delivering to the buyer. The buyer was entitled to claim damages for non-delivery. It is also not frustration if there was no express term in the contract about how the goods were going to get there. Important case that you will know. Zargi-Roglu against Nobly Thur. This involved a CIF contract for Sudanese groundnuts from Port Sudan to Hamburg. During the Arab-Israeli War, the Suez Canal was closed. The seller did not deliver. The seller argued it was not commercially possible to ship around the Cape of Africa The contract was fundamentally different. The seller said it would take 2.5 times as long and it would cost him twice the expense to use an alternative route. House of Lords said contract was not frustrated. The seller was liable for breach of contract. The change in circumstances was not so fundamental. There was no express term that the ship's route is only via the Suez Canal. It was a CIF contract. The buyer does not care how the seller gets the goods as long as he gets the goods. So you see, it is very difficult to frustrate contracts involving generic, unascertained goods. All right, why don't we take our second break now? We'll take a 10-minute break and we'll come back and we'll carry on. Okay, I'll see you in 10 minutes. Okay, hi. We've looked at the first type of unascertained goods. We're talking about generic, wholly generic, unascertained goods. Now let's look at the second type of unascertained goods, a specified quantity of unascertained goods out of an identified bulk. Example, I sell you 100 tons of wheat out of the 500 tons currently in my warehouse. This is the second type of unascertained goods. Now, if the warehouse blows up and all the goods have been destroyed, then the contract is frustrated at common law. Remember, Section 6, Section 7 does not apply because 6 and 7 only apply to specific goods. We're talking now about unascertained goods. Now, you know from your frustration lectures in contract law, you know the case of Appleby against Myers. The builder had almost completed the installation of a machine on the owner's premises, but the entire premises burnt down. The court said this was a frustrating event. What if the warehouse blows up and only part of the goods are destroyed? We will see later the case of Stearns against Vickers. But what happens if future goods don't materialize? Well, future goods can be unascertained future goods, or they can be specific future goods. Let's look at unascertained future goods. Howell against Copeland. There was an agreement to sell 200 tons of potatoes on a particular piece of land which normally produced that amount easily. Because of a disease, potato blight, the crop never materialized. The Court of Appeal said the contract was frustrated. It was impossible to perform. Compare that case to Sainsbury against Street, where 275 tons of barley was to be grown on a particular farm. Because of crop failure, only 140 tons were produced. The seller sold it to a third party, so the buyer was now suing for non-delivery. Seller argued two things. First of all, the seller said the contract was avoided under Section 7, and secondly, he argued Howell against Copeland. The court said, first of all, the contract was not a sale of specific goods, so Section 7 cannot apply. Secondly, although the contract was frustrated as to part of the crop that failed, the seller is not entirely excused from performance. it was an implied term that the seller must offer the crop actually produced to the buyer, and the buyer had the option of taking delivery of a smaller quantity at a pro rata price. Now, it is a bit odd. So, sorry, just notice the question at the bottom. Could I ask if the Hong Kong possession sections are for reference only? Do we need to extend our study to include those? The answer is they are for your reference only. You do not need to extend your study to include those. Your degree is an English law program. So that's only for your information and for your interest. But you do not, and you will not be examined on the Hong Kong possession at all. Okay. So going back to the Sainsbury against Street, what we're saying, it's just a bit odd that the seller must offer delivery of what he can, but the buyer doesn't have to accept. It is the buyer's option. But I suppose, you see, the case was before an amendment to section 30, subsection 1. We're going to have to learn this anyway later on in the syllabus. Let me just explain. Section 30, sub 1 says, if the seller delivers a smaller or larger quantity, the buyer may reject the goods. This section 30, sub 1 has now been amended by section 30, sub 2a. Nowadays, a buyer cannot reject if the shortfall or excess is just a small difference. Bear in mind also that although a buyer does not have to accept a smaller quantity, there is a duty to mitigate. So if the price is going up, the buyer should accept the smaller quantity offered. Otherwise, you see, the court might not allow the buyer this claim for loss, which could have been avoided. What about specific future goods? Because future goods are not always unascertained goods. They can be specific goods. We looked at me selling you Elton John's piano, which I have not yet bought from him. We also saw the real case of Varley against Whip. That was a case about the reaping machine. At the time of sale, the seller did not yet own that reaping machine, but the seller described it fully and agreed to sell it to the buyer. The court said the reaping machine was specific goods. What happens if specific future goods don't materialize? Well, treat it under the specific rules. In other words, section 6, section 7. Remember, the doctrine of frustration applies to sale contracts. Same rules. There has to be no one's fault that that thing has happened. If one party took the inherent risk in the contract, then the contract is not frustrated. We already revised the Australian case of McRae against CDC. Now, in contract, you also looked at a case involving a contract of sale of goods. CTI against Transclear. This case was in your contract manual, I checked. The case involved a seller who agreed to sell cement to the buyer, which the buyer wanted to export to Mexico. Both parties knew there was a cartel operating in Mexico by a third party. Seller tried to get cement from his usual Indonesian supplier, but the third party put pressure on the Indonesians, who then refused to supply the seller. The seller tried to get cement from his Taiwanese suppliers, but the third party applied pressure, so the Taiwanese refused to supply the seller. The seller did not supply cement to the buyer. Seller argued, hey, contract frustrated. buyer was suing for damages for breach of contract. You see, the buyer managed to get cement from a Russian supplier and is now suing the seller for the extra cost of getting cement from Russia. Court of Appeal said, no, frustration. Seller is in breach of contract. Yes, there was abuse by third party in pressurizing these suppliers, but did such conduct frustrate the contract? No. Delivery of goods was legally and physically possible. The buyer managed to get cement from Russia. It just cost more. Risk of failure was assumed by the seller. This was not frustration. Okay, let's look at remedies. Now, if the buyer has paid for goods in full or he's paid a deposit and the contract becomes avoided under Section 7 or frustrated, does the buyer get a full refund? Well, the answer is it depends. There are two remedies, the common law remedy and the statutory remedy under the Law Reform Frustrated Contracts Act 1943. I know you did frustration in contract law, but remedies is important in commercial. So I'm going to remind you of these remedies. Let's look at the common law remedy first. At common law, on frustration, the contract just stops. And parties are discharged from future contract obligations, but they are still bound by obligations which arose before the frustrating event. Example, you are supposed to give me, 5 chocolate bars yesterday, and you're supposed to give me 5 chocolate bars tomorrow. Today is the frustrating event. Well, the answer is you must still give me the 5 chocolate bars for yesterday, but there's no need to give me the chocolate bars for due tomorrow. But money obligations just stop. So any money passed before the frustrating event was not recoverable. The case authority is Chandler against Webster. This was one of the coronation cases, if you remember. The chap hired a room and he paid in advance. The king was ill, so the coronation procession was postponed. He wanted his money back. Court said contract was frustrated, but money paid in advance was not recoverable. The court said the loss lies where it falls. In other words, each party bears his own individual losses up to the frustrating event. So if you paid me a deposit of $10 million before the event, you can't claim back. Bad luck. Now, obviously, this was so unfair. So it was overruled by the House of Lords in Fibrosa against Fairbairn Lawson. An English company sold a machine to a Polish company. £1,000 was paid as a deposit. Then war broke out. This constitutes a frustrating event. The House of Lords said the buyer could recover the £1,000 because the consideration for payment had wholly failed, because no part of the machinery had been delivered. But Fibrosa itself is still not a satisfactory decision, because first of all, consideration must have wholly failed. That means partial consideration would mean no recovery at all. So if the seller sent one widget or gave the buyer one chocolate wrapper, buyer would lose out. The second reason why Fibrosa is not satisfactory is because it might still cause injustice. Maybe the seller used the deposit to finance the initial part of the contract. If there is a frustrating event, it would mean he wasted the money and he still has to give the deposit money back. So the seller loses out. These problems have now been remedied by the Law Reform Frustrated Contracts Act 1943. Note one thing straight away. The 1943 Act does not apply if the contract is avoided under Section 7, Sale of Goods Act. Why? Because Section 2, subsection 5 of the 1943 Act specifically says so. Now, you already did the Law Reform Frustrated Contracts Act 1943 in contract law, so please dig out your notes. It does come up in commercial. Excuse me. Let me remind you about Section 1. Section 1 sub 2 deals with money. Effectively, it rectifies fibrosa. Section 1 sub 2 says three things: sums payable, sums paid, expenses. The first thing it talks about is sums payable. What Section 1 sub 2 says: all sums payable before discharge ceases to be payable on frustration. So, if I owed you $1,000 before the frustrating event, there is no need for me to pay. Second thing Section 1 sub 2 talks about is sums paid. What it says: all sums actually paid before the discharge is recoverable. So Section 1 sub 2, you see, makes no reference to a total failure consideration. So this is a statutory right to recover money even if failure of consideration is partial. Third thing Section 1 sub 2 says is expenses. If a party incurs expenses in performance of the contract, the court can allow him to recover expenses, but there are three limitations. First, there must be some obligation to pay some money before the frustrating event. So, if the contract is payable only on completion, you cannot get any expenses. Second limitation: you cannot get more expenses than what was actually paid out. Example: I gave you a deposit of $1,000 and a frustrating event occurs. In fact, your expenses came to $2,000. Well, I'm afraid the maximum you can recover under Section 1 sub 2 is $1,000. You can't get more than what was actually paid in advance. Third limitation is that it is totally at the discretion of the court anyway. Now, this always depends on what is reasonable. If a machine was being built before the frustrating event, if that machine can be sold to a third party, the court will probably make a fairly small award. But if the machine only has scrap value, then the court might award a larger amount. Just one case on this: Galmerco against ICN. Contract for a stadium to hold a pop concert. The Spanish government closed the stadium for safety reasons. The organizer had paid $400,000 in advance. He wanted to reclaim the full amount because he said the contract was frustrated. The owners of the stadium said their expenses was $50,000. So they wanted to repay only $400,000 minus $50,000. In other words, they only wanted to repay $350,000. The organizer argued they had also incurred expenditure before the frustrating event, and their expenses coincidentally also came to about $50,000. The court said the stadium owners must return the full $400,000. The court said it was just in the circumstances. Both sides had expenses of about 50,000. So it was only fair that they both carried some of that loss. So you see, the courts have a very wide discretion. Let's take a look at section 1 sub 3. Section 1 sub 3 says, where a party has partly performed and the other party has benefited from it, it is possible to recover something. For instance, Cutter against Powell. You know this from contract law. You know this case from, I think it was under discharge of contract by performance. Cutter, if you remember, was to sail a ship from Jamaica to Liverpool. He was to be paid 30 guineas for the whole trip. He died halfway. His widow was suing for some of his wages. The court held the widow could not recover anything because it was an entire contract and Cutter had not performed the whole contract. Now, this decision was a bit harsh, but I suppose, you see, 30 guineas was 4 times more than the going rate in those days. So the court said, well, Cutter took the risk of all or nothing. So the widow got 0 from common law. But if the case was brought today, the widow will probably get something for Cutter's partial performance under the 1943 Act. Of course, if there was no benefit, then there would be no section 1 sub 3 payment. And whether a benefit was conferred is to be judged immediately after the frustrating event. The case authority is Appleby against Myers. The builder had almost completed the installation of a machine on the owner's premises, but the whole building burnt down. The court decided the builders received 0 at common law because there was a total failure of consideration. The builders also received 0 under section 1 sub 3 because the owner received no benefit. But if a party has received a benefit, how do we assess how much under section 1 sub 3? Just one case on this. BP against Hunt. BP agreed to provide Hunt with finance for oil exploration in Libya. When Hunt struck a large oil field, the Libyan government expropriated the field, but paid compensation to Hunt. Together with the oil already received, compensation came to £85 million. Now, BP, of course, had partly performed when the contract was frustrated. The argument was how much BP gets under section 1 sub 3. House of Lords said you must do 2 things under section 1 sub 3. First of all, you must identify the value of the benefit to Hunt. Court said this was £85 million. The second thing to do, the House of Lords said, is you must assess the just sum. In other words, the value of the services which BP provided. BP's expenses came to £34 million. So the just sum in this case was £34 million. The House of Lords indicated that you can't receive more than the just sum. So that's why BP got £34 million. Of course, there is nothing to stop parties agreeing to apportion expenses in advance, but only if they do that in advance. Note again, section 1 of the 1943 Act only applies to money. So, for instance, I agree to paint your house for $10,000 and 10 chocolate bars. The contract says, give me half when I start work and the balance on completion. Let's say a frustrating event occurs. The flat burns down. The 1943 Act applies to the money pot. The common law applies to the chocolate bars. So under the common law, everything just stops. It does not affect what was already due. So if you haven't given me my 5 chocolate bars, you still need to. because my obligation arose before the frustrating event. There is no need to give me the balance of the 5 chocolate bars because the contract has been frustrated. When does the contract come to an end? The answer is when the frustrating event occurs. Remember, the whole point about frustration is that neither party is at fault, but performance is impossible due to an unforeseen event. So on frustration, the contract automatically terminates. The case authority is Hilji Mulji against Cheong Yue Steamship. I don't think you need to know the facts of the case, but I'm going to remind you anyway, because it is a House of Lords case after all. The case name is very important. The case involved the charter of a ship for 10 months. Just before the date of the ship was to be handed over, it was requisitioned by the government. The ship owners thought this was only going to be temporary, so they asked the charterers if they still wanted the ship. Charterers said yes, but the ship was not released for 2 years, and the charterers then said, no thanks. The ship owners argued the charterers had affirmed the contract before the frustrating event, so they were bound by it. The House of Lords said, no. Frustrating event automatically puts the contract at an end. Affirmation is not possible because you cannot have an agreement to agree. Essentially, frustration kills the contract and discharges the parties from further liability under it. The contract is dead. The judge has no discretion at all to alter the contract. On the frustrating event, everything just stops. Just to remind you, if Section 7 applies, the 1943 Act does not apply. Why? Because Section 2, subsection 5 of the 1943 Act says so. So Section 7 says, where there is an agreement to sell specific goods and without anyone's fault, goods perish before risk passes to the buyer, the agreement is avoided. If Section 7 is avoided, the contract is avoided, it means the seller does not have to deliver and the buyer does not have to pay. Both parties are excused, but there are no 1943 Act remedies. The question is, what is the relationship between the Law Reform Frustrating Act and Section 7? I think I've just explained that. Because if the contract is avoided under Section 7, we don't need to discuss the 1943 Act remedies. Why? Because the 1943 Act remedies do not apply. If it's not Section 7 avoided, then you need to look at common law frustration. If the contract is frustrated, then yeah, you look at 1943 Act remedies. One last point, actually. Section 7 talks about where goods have perished. Supposing the contract is frustrated because of something else. Example, outbreak of war. So the contract comes to an end because of illegality. Does Section 7 apply? Well, the answer is probably no. There are no cases directly on this point, and the Sale of Goods Act does not define perish. But from insurance law, we know perish not only covers physical destruction of goods, but it includes perishing in a commercial sense. We looked, didn't we, at Aspar against Blundell versus Horn against Minister of Food. We also discussed the difficult situation of stolen goods, Barrow Lane against Phillips. Now, although there is no clear meaning of perish, it can only mean some harm to the goods themselves. So only if the goods are physically or commercially perished, will the contract be avoided under Section 7? If something else happens which prevents the execution of the contract, Section 7 does not apply. The contract may be frustrated at common law. If the contract is frustrated at common law, then the 1943 Act remedies are available, and the seller can get expenses. It seems really illogical, I know, but this is how things stand. Now, students are sometimes confused about terminology. Contract of sale, contract for sale, agreement to sell. Well, let me try and clarify that before we go any further. Okay. Contract of sale, agreement to sell, contract for sale, contract to sell. It all sounds similar, but they are not the same thing. I have a diagram up on screen. A contract of sale is a contract whereby the seller transfers or agrees to transfer property in goods for money to the buyer. That's Section 2, sub 1. So a contract of sale can be a sale or an agreement to sell. When property has passed to the buyer, it is a sale. It is an executed contract. When property has not yet passed to the buyer, it is an agreement to sell. It's an executory agreement. Section 6 relates to a situation when both parties had no idea that the goods no longer existed, but they thought they had an executed agreement. They thought they had a full-blown sale. Section 7 refers to the future. Parties agree to something in the future, but the goods perish before the contract is executed. It is an agreement to sell, and Section 7 has no application where property has passed. All right, now let's look at the transfer of property. We know the difference between specific goods and unascertained goods. We know how Section 6, Section 7, and the common law might affect the contract. What we are trying to work out is, when does someone become the owner of the goods? Because whoever is the owner has risk in the goods. That's what Section 20, subsection 1 says. In fact, risk is more important than anything else. In a way, risk is more important than property, because when goods are destroyed, parties want to know who has to bear the loss. The answer is the person with risk is the person who bears the loss. So if I sell you goods and I say right from this very second goods are at your risk, it doesn't matter who has property in the goods. If the goods are stolen or destroyed, it's your risk, your loss. It doesn't matter about property. It doesn't matter about possession. You must pay me. We only ever look at the rules about property if you and I don't agree anything about risk. That's because Section 20, sub 1 says risk passes with property. So if nothing is agreed about risk, then when does property pass? When does someone become the owner? Well, let's look at specific goods first of all. The starting point is always section 17. Section 17 says property passes when the parties so intend. So it depends on what the parties' intentions are. But how do we work that out? Well, you look at three things. First of all, you look at the contract terms. If the contract says property passes 3 hours after the buyer pays for goods, okay. But usually contracts do not actually say anything. I mean, most buyers and sellers do not usually think about property when they agree to buy and sell something. Usually, they just agree when delivery will take place and when payment needs to be made. So if the contract does not say anything, the second thing to do is to look at the circumstances of the case. The leading authority is Dennant against Skinner. Buyer bought a van in an auction. He paid by cheque. The auctioneers asked him to sign a statement which said that property in the van would not pass to him until the cheque has cleared. Sure enough, the cheque bounced. So the auctioneers argued, the intention was very clear because it was expressly stated in the signed statement that property was not to pass until the cheque cleared. The court said, no, the statement was signed after the contract was made. Now, remember contract law, your very first contract law lecture. I am sure you were distinguishing an offer from an invitation to treat. You would have looked at auctions. Section 57 of the Sale of Goods Act says, in an auction, the person who is bidding, person who puts up his hand, is making the offer. The auctioneer accepts that offer by the fall of the hammer. When he slams down the hammer, bang, that is the acceptance. Contract is made. That's why, you see, in Dennant against Skinner, when the auctioneers asked the buyer to sign a statement, it was too late. The offer and acceptance was complete when the auctioneer slammed down his hammer. Another case on this is Ward against Bignell. Seller sold a car to the buyer. It was agreed that the seller would keep the car until the buyer came back with the money to pay for it. Only then the buyer can collect the car. The Court of Appeal said this indicates that the parties intended for property to pass only on payment. We're trying to work out when property passes to the buyer. Section 17 says property passes when the parties so intend. So how do we work out what parties intended? Well, you look at three things. First, you look at the contract terms to see if anything was agreed. Second, you look at the circumstances of the case. If you still can't work out what the party's intention was, then the third thing to do is to look at the Section 18 rules. But let's finish the general rules first about when property is to pass. We've just looked at specific goods. Now let's look at unascertained goods. When does property pass in unascertained goods? Remember, unascertained goods are goods which are not specific goods. They are not identified nor agreed upon at the time of the contract. They are defined only by description. They depend on identification by some subsequent act of appropriation. Unascertained goods are only identified after the contract is made. That is what Lord Atkin said in Reweight. Now, with unascertained goods, Section 16 is the starting point, always. Section 16 says property in unascertained goods does not pass to the buyer unless and until the goods have become ascertained. The leading case is Re Gold Corp. Let me tell you about this case. Gold Corp was a dealer in gold. They sold gold bullion stored in the company vaults. Each buyer was issued with a certificate of ownership. The buyers could take physical delivery by giving 7 days' notice. The company went bust. They did not have sufficient gold to meet all of the buyers' entitlements. Buyers claimed co-ownership of the gold. The Privy Council said, no. Property cannot pass to any buyer because the goods were unascertained. Well, okay. Well, how do goods become ascertained? Well, essentially, there must be some outward sign of identification. They can be ascertained by exhaustion. Example, I have 22,000 tons of copra. I have a contract to sell the copra to 3 different buyers, A, B, and C. The wheat is on board my ship right now. I offload to A. The ship sails to Hamburg and I offload to B. Now, my ship only has 6,000 tons on board. That is the quantity I agreed to sell to C. So the 6,000 tons becomes ascertained goods. They are the only goods left on my ship. That's when unascertained goods become ascertained. Section 16 says property can pass as from that point. Property cannot pass earlier than that point. Those were the facts of the Elafi. CIF contract, 3 different buyers at 3 different ports. The court said the buyer's goods had become ascertained by exhaustion. They were the only goods left on the ship, and property can and did in the Elafi pass to the buyer at that point. This, the Elafi, is now Section 18, Rule 5.3, which we will see a bit later. So, Section 16 says property does not pass unless and until goods have become ascertained. Well, this does make sense because the buyer can't have property in goods until he knows which lot of goods are his. It does not mean property passes as soon as the goods are ascertained. Section 16 just says property cannot pass before then. So when goods are ascertained, then you go back to the general rule, Section 17. Property passes when the parties so intend. You look at the same 3 things to help you decide what the parties' intentions were. Contract terms, circumstances of the case, Section 18 rules. Now, there is one very, very important exception under Section 20 sub A, 20 big A, which deals with this second type of unascertained goods. It only deals with a specified quantity of unascertained goods out of an identified bulk. Example, I sell you 100 tons of wheat out of 500 tons right now in my warehouse. Section 20 big A was inserted as an amendment to the Sale of Goods Act by the 1995 Act. We will look at this very important exception later. I want to deal with the normal stuff first. So the general rules I want to deal with first. So where goods are specific goods or when goods have become ascertained, property passes when the parties so intend. Section 17. Only if the intention is not clear, then you look at the rules under section 18. There are 5 rules under section 18. The first 4 deal with specific goods. Let's take each one in turn. Section 18, Rule 1. 18, Rule 1 says, where there is an unconditional contract for specific goods in a deliverable state, property passes when the contract is made. It carries on to say, it is immaterial that time of payment or delivery is postponed. Let's break this down. Unconditional contract. What does it mean? Well, it does not mean there are no conditions in the contract. That would be silly. All contracts have conditions. Some are express, some are implied. In other words, what the goods are, the price agreed. What it means under Rule 1 is that it must be a contract which does not contain a condition preventing Section 18, Rule 1 from applying. The case is Varley against Whip. We saw this case already. The seller did not yet own the reaping machine, but he agreed to get it and then sell it to the buyer. This was a conditional contract. In other words, it was a condition that the seller must acquire ownership of the reaping machine first. It is not an unconditional contract because the seller was not yet the owner of the machine. That's why 18 Rule 1 cannot apply. Property cannot pass to the buyer under Rule 1. At the time I agree to sell Elton John's piano to you, you cannot own it. It still belongs to Elton John. I need to buy it first. So our contract is conditional on me buying it first. So that's why 18 Rule 1 does not apply. Rule 1 talks about deliverable state. What does it mean? Section 61 is the definition section of the Sale of Goods Act. Section 61 says it means goods are in such a state that the buyer under the contract is bound to take delivery of them. So if something needs to be done first to get the goods ready, they are not yet in a deliverable state. The case is Underwood against Burr Castle. This involved a condensing engine which weighed 30 tons. It was embedded in concrete on the factory floor. The seller sold the machine to the buyer FOR, free on rail. In other words, the seller would, the seller would detach the machine and get it to a train to deliver it to the buyer. The Court of Appeal said Section 18, Rule 1 did not apply because the machine was not in a deliverable state at the time of the contract because it was stuck to the concrete base. In Kulkarni against Manor Credit, a number plate to a brand new Mercedes car was only attached to the car when it was delivered. The court said a car without the registration plate is not in a deliverable state because the buyer was not bound to take delivery of it. We will look at this case Kulkarni again when we come to Nemo Dat. Section 18 Rule 1 also says it is immaterial that time of payment or delivery is postponed. So if goods are In a deliverable state, property passes at the time the contract is made under Rule 1. Immaterial means it doesn't matter whether the buyer has paid for the goods or whether he's even got possession of the goods. We just talked about the case Dennant against Skinner. The court said the contract was made at the fall of the auctioneer's hammer. It was an unconditional contract for specific goods in a deliverable state. So property passes at the fall of the hammer. It was immaterial the buyer has not paid, nor has he taken possession at the time his offer was accepted by the auctioneer. So you see, the passing of property and the right to possession are two very different things. We're talking here about when parties have not agreed before the contract is made about when property is to pass. Only if the intention was not clear, you need to look at Section 18 rules anyway. For instance, in Underwood against Burr Castle, this was an FOR contract, free on rail. This showed the intention that property and risk was not to pass until the machinery was safely on board the train. It was specifically agreed before the contract was made. So that's why Section 18 rules don't apply. Section 18 only applies if parties do not indicate what they intend as far as property passing is concerned. Now let's look at Section 18, Rule 2. 18 Rule 2 says, if specific goods are not yet in a deliverable state, because the seller still has something to do, in other words, maybe to pack it, then property passes when that thing is done and the buyer has notice of it. Example, I sell you a specific car. I'm to respray it. Whilst it is in my garage, the car was stolen or maybe there was accidental damage. Well, property has not passed to you yet because I've not done the respray yet under Rule 2. But even if I have resprayed the car, property still does not pass to you unless you, the buyer, have notice of it. Of course, this is also a Section 7 case. Remember, where there's an agreement to sell specific goods and it's nobody's fault, but the goods perish before risk passes to the buyer, then the contract is avoided under Section 7. Because property has not passed under Section 18, Rule 2, so risk has not yet passed to you. But there are no 1943 Act remedies. So even if I've done the respray, I don't get expenses. Note, notice under Rule 2 means actual notice. So if the seller sticks a letter in the post to say, hey, I've done the respray now, and the letter's lost in the post, Adams and Lindsell cannot help. Property does not pass to the buyer because there was no notice. So the buyer has no notice that the seller has done that thing the seller is supposed to do. Of course, you might want to query whether a third party can give notice. So if your next door neighbor tells the buyer, hey, I've just passed the garage, that respray looks fantastic. Now, I wonder where a third party can pass notice. Now, you know the case from contract law, Dickinson against Dodds. Remember, in this case, seller wrote to the buyer offering to sell some land. And he said, the offer, I will leave it open until Friday, the 12th of June at 9 a.m. The seller sold the land to someone else on Thursday evening. And the buyer heard about this from a third party. On Friday, the 12th of June at 7 a.m., the buyer accepted the seller's offer. The court held no contract, because once the offeree knows the offer has been withdrawn because he had sold it to someone else, it's too late to accept the offer. The decision is seriously criticised, because how is the offeree to know how reliable the third-party source of information is? But it does stand as a decision. So query whether a next-door neighbour, a third party, can give the buyer notice that the seller has done the thing he promised to do. The respray to do, now there's the respray that has been done. We're looking at section 18 rules. We've just done rule 1 and we've done rule 2. Well, that's a good place to end this evening. We've already done a huge amount. So we'll end the lecture there, and I will see you tomorrow, and we will start off with section 18, rule 3. All right, good night. So I'll see you tomorrow. Okay.